Let us start with this why I gave this topic is basically injury report or giving an wound certificate. Somewhere if you go to southern side, they say this is an wound certificate, not an injury certificate. But it is one and the same. An injury report is the base, an advocate can say. Most of the young budding advocates, when they initially start their practice, they usually deal with matters of 323, 324, 325, 326, and 307. So these are all bodily injuries in their previous 4 to 5 years. Then they may go to uh, dealing with cases of 302 and other much more serious offense. So I thought we'll go through this certificate. Now we can just see what is an injury report. It's an crucial document that details an individual injury, typically in workplace incidents, accidents, or other situations where legal or medical documentation is necessary. The medico-legal implication of injury report involves the intersectio medical and legal consideration aiming to accurately capture the nature and extent of injury for both medical treatment and potential legal proceedings. Means by this certificate, we usually do medical treatment as well as provide our expertise opinion to the investigating agencies and also to the honorary courts as and when required during trial so that accuracy in knowing what is injury, what are their implications and their connection or application with the law and evidence can be done in a better way for betterment of justice to all the victims. Then what is an injury? Medically, what we define injury is a damage to any part of the body due to application of any mechanical force. So medical injury in true sense is mainly a bodily injury only. What we feel in medical science is that if there is bodily injury, then only it is an injury for us or damage to any part of body. But legally, under section 44 IPC, the definition has a very wide scope. It reads any harm, whatever is illegally caused to any person in body, mind, reputation, or property amounts to an offense of injury under 44 IPC. If you go through this citation of 44 IPC, initially it starts any harm. So it's not only bodily injury, any type of harm. It may be social harm, it may be any type of harm to a person, but it has to be caused illegally. Means that harm should be against the law of this country. It cannot be a harm just like there is, we can say, judicial harm. The investigating officer may use a reasonable force as the case deemed to be, and that may create some harm to the body of the accused. But that is not an illegal harm, that is an lawful harm caused to the individual who is accused of some offense to derive and lead in that investigation. So this harm has to be illegal only. Then it should be by body, mind, reputation, or property. So if we read this definition properly legally, this 44 IPC is just like a bigger umbrella which compasses all type of harm, whatever a person may cause in this society. I will just go in brief just to know what is basically an injury. What are the types of injuries? First is a blunt force injury. Blunt force injuries usually are caused by a blunt object or surface, such as bruises, contusion, and abrasion. So these three types of injuries we medically label as a blunt force injury. And if we label it as a blunt force injury, it has to be by a blunt object. Take an example common like a wooden bamboo is a blunt object. A stone is a blunt object. Second is a sharp force injuries. Now these sharp force injuries result from a sharp edged or pointed object like a dagger or even a kitchen knife having a point with single edge or double edge shaft. It depends on the weapon. Now it leads to cuts, stabs, or incised wound. So whenever we write in the wound certificate that it is a cut, it is a stab or a incised wound, or sometimes some medical officer are fond of writing perforated wounds. It is just a variant of stab wound. That means it has to be caused by a sharp force injuries, that is by a sharp edged or a pointed object like a dagger, or even, pointed object can be iron rod, which has a point. Usually, we should not feel only incised wound can be done by a weapon like chaku or knife only. So any object which has a comparatively sharp edge can cause incise wound. Any object, instrument or weapon which has a comparatively tip, it can cause a stab or perforated wounds. So this is basis of sharp force injuries. Third injuries what we commonly see is a firearm injury. Now the gunshot wounds and bullet trajectories are examined to understand dynamics of shooting incident. Means this all firearm injury, usually in an injury report, medical officer will write as wound of entry, wound of exit, or if it is by a smooth bore firearm, we may have multiple wound of entry in form of a pellets. So that is how it relates to firearm injury. Then we also have a thermal injury, which is caused by application of extreme temperature. Extreme temperature does not mean that it is only increased temperature. It can be either way, just like application of a hot fluid, application of a dry flame, or if you go in tropical countries, just like Kashmir or tropical areas, there we may get frostbite, which is due to very low temperature in minus 10 degrees, 20 degrees, and the body is always in contact with such a low degree. So thermal injuries or misconception, I have for my 25 years of my medical legal practice in the court of law, it is most of the advocates or medical officer feel thermal injuries only by increased temperature. No, it can be either way also. Next is the asphyxial injuries. Now, what are these asphyxial injuries? They result from lack of oxygen. Any activity leading to lack of oxygen, they are labeled as asphyxial injuries. And few example is strangulation, hanging, suffocation, drowning. But that is not the end of this. Any asphyxial, I can give you one cardiac poison in which even after poisoning there can be hypoxia, decrease in the oxygen to the cells or the tissues, and that asphyxia can cause also bodily injuries. So all these are asphyxial injuries. Then you can see electrical injuries commonly caused by electrical currents. Now that current may be AV or DV current, direct current or alternative current, and based on AV or DV current, the wound of entries are formed commonly, which leads to burns or internal injuries. Now, electrical injuries commonly medical officer will write as a crater or wound of entry of any electrical burn. That is to be written. Now, in this we can add in electrical injury, there is something called as thunderstorms. There are something called as lightning effect. वीज पडते आपण जे मराठीत म्हणतो, that lightning effect can also cause a fern-like injury pattern on the body. म्हणजे जसं ट्रीचे branches what we see, that same branches is depicted on the body of the individual if there is a lightning effect on that. So these are basic types of injuries. Then we'll just give you, see how we classify mechanical injuries. Just in a single slide, if it is by blunt force, then what are the type of injuries? First one is abrasion, second one is contusion, third is laceration, last is the fracture. So all these injuries, what names has been, is only possible by application of blunt force. Then abrasions, how many types we have? We have scratch abrasions, graze abrasions, pressure abrasions, and impact abrasion. I'll give one example of scratch abrasion, which we commonly encounter in strangulation cases because of the nails of the accused. He may scratch that neck area to strangulate that individual. Graze abrasions are commonly seen in road traffic accidents. Pressure abrasions are usually all these ligature marks seen in case of hanging or strangulation or ligature strangulation. Second is contusion. Contusion can be intradermal, means between the two skin part, between the dermas. It can be subcutaneous, means below that. So superficial contusions are always intradermal. We have a skin as a superficial layer protecting layer to our body or the tissues. In that dermis also we can get minute bleeds that are called as intradermal. Then is subcutaneous below that. Then is deep contusions which are commonly seen in muscles, ligaments, or also maybe a part of fracture bone along with the bony fractures. Then lacerations. Lacerations can be split lacerations, stretch lacerations, cut lacerations, and avulsions. Now see why name cut is given, because this mimics like an incised wound. So here a doctor has to be careful that these cut lacerations on external examination will look like an incised wound. And then fractures. Fractures again, we have many types of fracture, simple fractures, complex fractures, compound fractures. Then second is due to sharp forces. They are incised wounds, chop wounds, and stab wound. See, this chop wound is a variant of incised wound only. I can give very common example. In rural areas, we have axe, कुऱ्हाड जे आपण मराठीत म्हणतो. So these chop wound are typical incised wound. म्हणजे this you can just examine externally and I can identify it is a variant of incised wound, that is a chop wound, commonly caused by heavy, sharp cutting weapons like kurad, axe, or we have choppers, a mutton for mutton cutting they are using. That is also a heavy cutting weapon. They will cause chop wound. Then stab wounds because of point of the weapon. Then in miscellaneous we have firearm, we have defense, and all type of injuries. Now we'll just show you pictorial presentation of how it looks. This is what is abrasion seen. You can see this is a graze type of abrasion. We also, the second name given in science is a brush burn. Brush means BRUSH, brush. जे आपण means what we use clean our cloth. So त्या brush, if you rub it over your skin, you will get this type of abrasion. This we commonly encountered in road traffic accident because of dragging of that body across the friction surfaces. Second type is you can see contusion. See, this is classical under eye contusion. Why I have given this picture is this under eye contusion sometimes people may feel or even the few medical officers may feel that this is a normal phenomena. कि डोळ्याखाली loose tissues are there. So there is reddening of all this. No, this is also a type of contusion usually seen when there is a fist blow. म्हणजे जेव्हा मुक्का मारतो आपण ऍडव्होकेट साहेबांना हे माहित, जेव्हा there is a quarrel between two parties and if there is a blow given by a fist and if it is over the eye, this type of contusion usually we will get. Then you can see this is a contused lacerated wound or CLW. You can see the depth, this is the floor, these are the edges, this is a fresh injury we have given for your presentation. So actually CLW will look this. We are not means cleaned and sutured, or this is, see this end, this lower end, you can see it's not sharp. I'm moving my cursor, but you can see this edge is comparatively sharp of this contused and lacerated wound. So this study of the injuries, edges, floor will help us in determining the type, even in some cases the name of the weapon. See, this is classical incised wound. Classical incised wound would be spindle shape. Spindle shape means this is called a spindle. And this end, please take care. Please check my cursor. This end where it is tapering, म्हणजे जिथं आपली injury कमी होते. This we call in medical science as tailing of the wound. This one. Tailing of the wound is always at the end of the wound. And this tailing of the wound gives us direction of infliction of injury by the accused. If I study this injury, I would say that the injury has started from this end, then this is the center is the maximum depth of the injury where maximum force is applied. Then the lateral tailing part is the part of the injury when the weapon was slowly and steadily removed from the body. So this is an incised wound. You can see this is a stab wound. Undoubtedly, the depth of the stab wound, being a three-dimensional structure, cannot be shown in a two-dimensional photography. But this is a classical stab wound. You can see the stab is over the back. And this, if you see, again there is tailing. So when there is tailing, always it has to be incisive wound. It cannot be a stab wound. So in this photograph, as a medical expert, I can easily opine this injury and this is a stab wound. However, this injury is a superficial incised wound. You can see fracture. This is a fresh injury. Yesterday only we did this case. Road traffic accident. This is a leg part, left leg, lower part of the leg. Usually, when we see this position of leg, as an good forensic expert, I can see what type of weapon also has dashed this individual. So you can see these two fractured end. This is tibia, lower end of tibia and fibula. This is the ankle joint. So this we label this injury as comminuted fracture and complicated fracture. It's not a simple fracture because it is an open fracture. And see this firearm injury. This case we did 3 days before only. He is a CISF Jawan. He was posted in Geo World for duty. For some reason, with AK-47, he shot himself. See, this is wound of entry. So, all my dear advocates and doctors, all delegates on this Zoom, always keep in your mind, wound of entry is not to be mandatorily circular in shape. This we say contact shot, which is satellite in shape or star shaped. This is wound of entry in a contact shot. Contact shot means the tip of the barrel was in contact with the skin when this firearm was shot by the individual. The next photo is ideally seen. This is a defense wound, what we say. See, this is a type of laceration only. Now these hands are the defensive part of our body. Means once we get this defense injury, we can easily opine to the court or the IO that this victim has resisted when he was assaulted by the assailant. So this is the importance of a defense injury. This is classical defense injury. Now, what is more important and would be more helpful for the defense counsel are these injuries. This is what we say fabricated or self-inflicted injuries. You can see in this, see these are superficial, few are healed. This is a fresh injury. Fabricated means one person may create injuries on such part of the bodies just to falsify the allegation against the accused. Now, this is commonly done usually and is a planned process. And if somebody is to be framed by someone, so these fabricated injuries, self-inflicted injuries during defense is of importance to give proper justice to the accused. Now, after this brief projection of the type of injuries, we how do we classify injuries in brief? So, for medical legal interpretation, injuries can be classified as accidental injuries, which are usually caused by accident, suicidal injuries, which are caused by suicides like hanging and all this. Then is homicidal injuries caused by an assault. Then is defense injuries, that means the injuries which are caused as a part of defense by the victim. And last, what we have seen in photo is a fabricated or self-inflicted injuries. Now, what is an hurt? We'll define hurt. Now, many times during cross also, or even the PPs or public prosecutors do ask us, the prosecution witness or the medical expert, की डॉक्टर सिंपल इंजुरी काय आहे, याच्यातल्या काय सिंपल इंजुरीज आहेत, काय आहे. So usually simple injury neither is defined, medico legally, neither we could get in any definition given by any IPC, just like given for injury under 44. But this hurt, which is defined under section 319, which defines an hurt, is used as a synonym of hurt. म्हणजे hurt आणि simple injury is one and the same. We have read in one of the Honorable Supreme Court judgment that this definition was used in simulation to prove whether it was a simple injury or not. So we indirectly can say the definition of the hurt under section 319 IPC can be used for detecting or determining simple injuries. Now hurt, what it says, non-extensive injuries which would heal rapidly without leaving any permanent deformity or disfigurement amounts to simple injury. If we go by type of injuries and classification, all injuries like CLWs, incised wound, stab wound, or open fractures will always leave a permanent scar. So that by definition cannot be taken as simple injury. But yes, abrasions, superficial minor injuries, superficial incised wound, which may not leave a permanent scar, can be taken as a simple injury under the definition of the hurt, that is 319 IPC. Now, all advocates better know, we all are well known with this section 320 IPC, which gives few criteria for labeling it as a grievous hurt, that is GREVIOUS. It is not grievous, it is grievous. So what are the criteria? First is emasculation. Second is permanent privation of sight of either ear. So here, advocates and medical officers should always keep means proper in mind. There has to be a permanent privation. Privation means damage. So there has to be a permanent damage of sight of either eye. Just because of trauma, he may lose vision for 10 days or 2 days. That cannot amount to an offense or injury under IPC. Yeah. Grievous hurt basically is defined under 320 IPC by law. Now, what IPC has said, how to know whether which is a grievous injury. Now, this can be used by medical officer while providing opinion or by the advocates while arguing the case in the court of law. Now, what it states, what are the indications under 320 IPC to label it as a grievous injury? Number one is emasculation. Emasculation simply means that loss of masculine character of that individual. Second is permanent privation of sight of either ear. Means permanent privation means there has to be a permanent loss of either eye. Means one of the eye. It may be both also. Now, what do you mean by permanent loss in this? That because of trauma to say right eye, if that person may not be able to, have a vision with that eye, affected eye, or 2 days or 10 days, that will not amount to 320 IPC, but it has to be a permanent damage. Same with hearing of either ear. Fourth one is privation of any member or joint. Privation is a permanent damage. Member we define. Advocates are also well aware with this section better than the doctors. But member is any part of that individual body having a distinct function. Means I will give a better example. Distinct function means what? Say the terminal phalanx. I will give an example. Say this is my second finger. Now this part, even the last what I am moving now, I am keeping my finger hold. See, I am moving only my terminal end. Now this terminal end is also a distinct part of the body. So even though there is injury to this or fracture of this, will also amount to 320 IPC under the clause number 4, that is privation of any member or joint. So any member can be any part of the human body which can function independently in simple language. Then permanent destruction of power of any limb, any member or joint. Permanent destruction has to be there. Means what happens many a time, there is a say fracture of right lower and what we have seen. See, after that he needs operation, he would be ambulated for 2 to 3 months. Then he need physiotherapy for next 6 months. And during that period, if this, some may feel, maybe the investigating agencies or the defense lawyer, that this in this 6 months period, he has lost some mobility of that part of the body. So it amounts to permanent destruction. So that is not a permanent destruction. Permanent destruction means there has to be permanent loss of the function because of that injury to that part of the body. Just like traumatic amputation of say right ankle joint. म्हणजे ankleच्या खाली joint is traumatically because of trauma needs to be removed. So that is permanent damage. That will amount to 320. If it is repaired, it is fractured. So that will be grievous under clause of fracture. That is the last one. Fracture of bone, not under this permanent discussion. Then permanent disfigurement of head and face. See, this one is debated in the court of law in cross, that any injury, and that is one of the reason, nowadays, I think before COVID, there was amendments in the Criminal Act I think, and this vitriol H, throwing of an acid usually over the face of mostly females are affected, not all females, but mostly is taken under 326 serious offense. Previously, it was not under 326. So this can be applied there 320. See, any injury leaving a scar to the head or face can be taken under 320 IPC and it can be labeled as a grievous hurt. Then is fracture or dislocation of any bone or tooth. See, fracture and dislocation of bone is a very easy identity. Medical officer easily understands, as well advocate. What is more issue what I have seen in my such a long career is regarding the tooth. Now sometimes some medical officer opine he right upper quadrant incisor teeth was loose at the base. Now then a dilemma comes, loose at the base, whether it is a grievous injury or a simple injury, or there is some identity as dangerous injury also. But unless, what is dislocation? Dislocation is that the root of that teeth should be moved from the anatomical position of the routine. Means in simple words we can say एखाद्याचा दात ज्या जागेवर आहे, if I want to say that the teeth is dislocated, then तो दात त्या ओरिजिनल जागेहून हलून दुसरीकडे गेला पाहिजे. Then only it amounts to dislocation. Just because it was loose because of trauma doesn't amount to dislocation or 320. It will be in other type of injuries. I will give you a photo of all this. This is emasculation, removal of the male genitalia amounts to emasculation. All this will cause disfigurement of face, you can see, and loss of vision of eye also. This trauma to here, you can see bleeding. This bleeding is because of trauma. This trauma has ruptured the eustachian tube, tympanic membrane, which may lead to permanent losing of hearing by this individual. So this is a fracture. You can see this bulge. This is fracture, and this is a displaced fracture over the wrist. Then this is ideal disfigurement of face after burns. This person was burned by someone, and this is what is called as we can label it as disfigurement of face. This one also, and this last clause we are not taken. I will show you this why we have taken that. This is last clause. Now this is useful to either prosecution also and defense also. See, this can be misused and this can be used properly. If any public prosecutor is online, he or she may agree with me. So the last clause of 320 speaks any hurt. So it is defined under 319 IPC. So that means in this last clause, simple injury is also included. So this is gist of this clause. Any hurt which endangers life. Only that hurt should endanger life. It should create, that injury should create an impact on the body in a way by way of which it can endanger the life of that individual. Take an head injury resulting in minor subarachnoid bleed. That can endanger life in due course of time. Or which causes the victim to be in severe bodily pain, or which prevents the person from following his ordinary suits. So this is very important legally to determine or apply 320 IPC based on this criteria, that the person should be prevented from ordinary suit of life for a minimum period of 20 days. Now in this, how it is misused by some, I've provided few opinions on this, that some victim may get admitted in any private hospital, government hospital, or any nursing home, and he may be on bed for 20 days, and in that 20 days वो अच्छा खा पी रहा है, and indoor papers are made, and that papers are submitted, and prosecution may based on this may consider it as a grievous hurt, and revision of more serious charges can be made based on this. But this is not the fact. What law says, what 320 says, that injury or bodily pain, not only injury, any bodily pain, which prevents the person from following his ordinary pursuits of life, then only it is a grievous hurt. What do you mean by ordinary pursuit of life? For every human being, it may be me, you, or any human being, what is our daily routine? Getting up from bed, doing brush, going to lavatories, then wearing clothes, buttoning, unbuttoning, shaving, So this ordinary suit should be hampered or it should be completely prevented because of this bodily injury or pain. And for that reason, if he is admitted for 20 days, then only this clause can substantiate and we can apply 320 section IPC against the accused in this case. So this is to be cautiously admired by the medical fraternity as well as the prosecution counsels and the defense counsel in this. Now, age of injury, again, this is, a debatable criteria. We are always asked, and even the prosecution is also interested to correlate it. If they get age of injuries, they have a firyadi stay or prosecution case. And this age of injury, if corroborated properly with the time of incident or assault, then this corroboration may be beneficial for conviction. So age of injuries is again a very important aspect for medical officers. Now it is usually by a healing process method or it depends on various factors. So what are these? We'll look into brief. Now see this type dating of an abrasion or age. Now any abrasion fresh is always bright red in color. When it is red scab is found, म्हणजे आपण जी खपली म्हणतो आपण मराठी. If red scab is formed, it is 12 to 24 hours. Now along with this scab, you can see blood or serum. He is always oozing out from that. And reddish brown scab, 2 to 3 days. Healing from the periphery is 4 to 7 days. And complete healing will be there within 10 to 14 days. Now see, these are only presumption of time of death based on researches. But there are various factors. I can give you example. If a person is diabetic, severely diabetic. Now in that diabetes, healing process is already slowed down. So these days may be increased. But this is for a normal individual. This time schedule is followed. Now if you see on right side is a bruise. You can see bruise or contusion. Now there are various color changes. Above we have posted a pie chart or a diagrammatic chart. You can see from red to blue, blue to violet, violet to green, green to you can say faint green, then yellow and healing skin color. Now actually this will look in this way on this. See, this is fresh injury, that is red to pink in color. Then this is dark violet, you can compare with this. Third, see, this is greenish tinge. See, green means doesn't mean that it will be green. That will have a greenish tinge. Then this is towards yellowishness, this part, and this is normal skin texture. Now, what age scientifically we can give based on the color changes? Red, 0 to 2 days. Blue or purple, say this is blue or purple. Now, why blue or purple? If a person has a very bright fair skin, so in that blue color may not be appreciated, purple color may be. If a person is means middle skinned or gahu varna, what we say, or dark skin, in that we'll get this blue color. So both is one and the same. Blue or purple will be within 2 to 5 days. Then green will be 5 to 7 days. Yellow will be 7 to 10 days. Brown 10 to 14 days. Why we have taken this brown? Because most of the Indians skin color is near to brownish tinge. Most of the Indians, except Punjabis or fair skin people or Kashmiris. So 2 to 4 weeks, a bruise heals by resolution. So in science we say contusion and bruise will heal by formation of scab, while the contusion will always heal by resolution. Is a contusion will never ever leave a scar on the body. Now next would be, what are the factors influencing this? Wound healing. Age, older the age, more is the days required because immunity is dropped, comorbidities are there. Then nutrition. Now if a person is malnourished, undoubtedly healing process would be slow. Then comorbidities. One of the example I gave like diabetes, if there are comorbidities, yes, it will healing would be delayed. Then medication. Now there are few medication. Best example I can give, a person after doing bypass is on blood thinners for longer period of time. So heparin and all these. If an individual or victim is on blood thinner or like drug medication, undoubtedly in that clot formation would be delayed. If clot formation is delayed, fibrin deposition would be delayed. If fibrin deposition is delayed, formation of scab would be delayed, and undoubtedly there would be delayed healing. Then the lifestyle means what happens that for any injury to heal, we say that immobility of that part, injured part, it should be immobilized so that healing would be faster. Now there are lifestyle, few people, they may not keep their injured part immobilized, they may always move, then the healing would be delayed in such cases. There are multiple factors. Now injury, what are the legal implications? Means where the opinion of the medical officer basically can be utilized by the prosecution or defense or the honorable courts to derive at a logical conclusion before giving any verdict in the court of law. First and foremost would be cause and manner of death. If that person dies of injury. See, there are some cases in which injured is admitted in hospital, say sections like 326, 307 is filed, and after say 10, 20 days or 12 days, as a consequence of that injury, that victim may die. So in that, the cause of death and the manner of death. Cause is usually what has caused the death. Manner means what way the injuries are inflicted and it has led to the death. And second is criminal investigation. Means this opinion provided by the doctors helps or aids in providing leads to the investigating agencies while investigating the case. Identification of perpetrator. Now, sometimes I have opined this, in prosecution in few cases, and defense and the court may also feel how we can identify this by, a person accused can be identified by examination of injuries. See, when we examine injury, if there are few typical injuries, I'll give an example that there is some fracture called as signature fracture over the head. Signature fracture. Now, these fractures are only and only caused by hammer or hammer-like weapons if inflicted on the head. So if I get such type of injuries as a medical expert, and if I am having reasonable expertise in forensic science and good experience, I would say this is a signature fracture mostly caused by hammer-like weapon. So based on this, police can search for such weapons and they can recover such type of weapons from the accused or from the crime scene wherever it is available. Now in that weapon or on that weapon, there can be fingerprint of the accused. There can be some foreign body material, maybe in the form of saliva, blood, hairs of the accused, or nails of the accused present over the handle of the hammer or the blade of the hammer. So then, by doing that laboratory test, we can easily identify the accused. Post-mortem interval, again helpful. How it is helpful? See, if a body is brought dead to me, having multiple injuries, if there are classical injuries like incised wound, contusion, abrasion, so I can say that these are antemortem injuries and the time of injuries based on the color changes or healing stages. I can say it can be 4 days, 3 days, 5 days, or between 3 to 5 days. So that interval we can easily do. And victim identification. See, this we have done n number of time. You can search my name on Google for this. And we are given victim identification also based on injury. I'll give one example. He say a case is brought to medical officer by any investigating agencies, and there is an history of assault over the face, and there is injury over the lips, beneath the lips, and the alveolar means the दाताच्या वरचं जे चमडे alveolar, that margins are reddened, and we need to examine. And during that examination or taking X-rays, we may find some implant, we may find some enamel which was present over the body of this injured individual or the accused. Now, based on this, if there is an implant, I would say every implant has is, if you remove that implant and go, there is a signature on the implant, name of the company, specific type. So based on this, we can ask this company key where these implants are supplied. That we have done 2 cases. One of the landmark was Kurla police station case. We got conviction under 302 in this case. So if proper wound examination is done by a good expert, we can aid in investigation in a good sense. Now next is medico-legal implication, where it is done medical evidence, insurance claim, this is a civil aspect, legal liability, worker protection, legal compliance, workplace safety improvement, subsequent medical treatment, and disability. See, in all these cases, the injury report can be useful. Now, these are all brief of where it can be used, that I will not go in details. Now, this is which IPC is. I can say whether it is dependable or is based on the wound certificate or the injury certificate given by the medical officer. First and foremost is 325 IPC. Now we the advocates know what is 325. Just read out. Whoever except in a case provided by section 335 voluntarily causes grievous hurt. That means it has to be grievous, shall be punished with a term which is mentioned in this act. Now it is a cognizable and bailable and triable by a magistrate. Second IPC which is depend on injury opinion is 326. It reads voluntarily causing grievous hurt by dangerous weapon. In 325, there was no dangerous weapon, but to apply 326, the injury has to be caused by a dangerous weapon. Again, this dangerous weapon is defined by law under section 326 is, you can see this, any instrument which is used as a weapon of offense, used for stabbing, cutting, it is a dangerous weapon. So 326 is again dependent on reporting of injury. Then is, what is it? It's cognizable, and nowadays it is non-bailable. It is triable by first class magistrate or session court. Correct me any lawyer if I'm wrong in this. Next one is 327 IPC, voluntarily causing hurt to extort money or to constrain any illegal act. Again, there the injury report is necessary for application of all these. This is more important, I would say, whenever the investigating officers wants to apply section 302, that is a charge of murder, provisions of section 300 IPC has to be satisfied. So, and these 300 IPC provisions are dependent on the injury. So it says the injury inflicted on the disease was actually the cause of death. Means direct causation is there in law. The injury was sufficient in the ordinary course of time to cause death. This is always asked by us, by in chief also, and also by the defense counsel, whether it is sufficient or not to cause death in ordinary course. Ordinary course means considering that even though the patient was not treated of this injury, he will die only. So that is the basic meaning of ordinary. In case of multiple injuries, through examination is necessary to determine which injury, which organ led to death. See this, the good counsel always uses this for defense for his client. Is commonly applicable to the best of my experience and knowledge when there are more than one accused, and when there is more than one weapon, and when the injuries are more than one. So in that is very important that if there are 5 accused and 2 weapons are used to determine which injury was more fatal to cause death, then that injury is caused by which type of weapon. So then that weapon was used by which accused. That accused will have more serious punishment if you compare with the other minor injuries caused by, even though they apply furtherance of common intention, section 34, but this defense usually takes the contradiction or benefit of doubt for their clients based on this section. Now see, what are the causes of death? Shock, immediate. Vagal inhibition is immediate. Air embolism is immediate. Vital organ injury is immediate, and some natural disease. Now remote causes means delayed. Crush syndrome, DIC, necrosis, infection, oblique septicemia. See, this is commonly seen, infection oblique septicemia. If an injury is treated for say 10 days in an accident and that person dies, usually dies of septicemia. Then is the neglect. Here, most of some defense counsel do take a suggestion that the infection because of the injury is due to negligence of the doctor or improper treatment given by the treating doctor. Now what we'll do, we'll directly go to the pro forma. What is this? This we can discuss. See, this is, preliminary details we all medical officer has to fill into an injury report. Pro forma, where is pro forma? So this is ideal pro forma, what it should be. Undoubtedly, this is not given at sign also, this pro forma. They have their older pro formas made by corporation. But this is what is ideal. It has to be. It needs to be done by government of Maharashtra. In this injury report, we can see first and foremost is MLC number, OPD number, preliminary details, and see this is important identification mark. See, I've seen many certificates which are given by the medical officers at PHC, even in Sion Hospital, KM Hospital, if it is given by medical officers, they fail to give identification marks. And this identification mark is very important. What happens, the defense usually crosses whether he is the same individual which you have examined. And if I don't have this identification mark in my report, after 4 to 5 years when this case is on trial, how can I remember that, that is the same victim I have examined and these injuries belong to this victim only. So identification mark medical officer has to take care the minimum to proper identification mark has to be put into. I can give you one example how it can be properly said. So we can say a mole on right side of the chest, 5 centimeter lateral to the right nipple, 10 centimeter medial to mid axillary 9. So this way the anatomical fixation is important. Otherwise we cannot identify anyone in this when we go to court in after 4 to 5 years. Then brief history is again important. This aspect, is very important for prosecution also. What history was given to the medical officer, because medical officer is a neutral person in investigation. He is an expert. His role, even though he is said as prosecution witness, but his role is to give an fair opinion based on the findings and the scientific findings. So brief history has to be in the words of the victim. Sometimes, doctors say, अरे ये मैं नाम नहीं लिखूंगा इसका, why you are taking name of the accused, और ऐसा हुआ ही नहीं था. Medical officer should take care. History is given by the victim and it has to be in his or her own words. We are not right to change any content of the history. Write whatever they say. It may be true, it may be false. That is the investigating officer to look into that. Then you can see investigation, what was advised, whether that investigation was received by the medical officer before providing opinion, that column. Now this is what is, gist. I say this injury report, see these columns, this is important for the courts, prosecution lawyers and the defense lawyer. It has to have this many columns. Serial number, name of the injury, size of the injury, then the on which part of the body it is inflicted, type of injury, kind of weapon, age of injury, and then the remarks, if any, for the doctor. See, this completes complete pro forma of injury. Again, this is not uniform in the state of Maharashtra. हर कोई अपना use कर रहा है. Old traditions are going on. Nobody is ready to change, and courts are really fumbled by improper opinion. Even the prosecution lawyer finds difficult to sustain that case if a medical officer will not give a proper opinion in a proper format. So serial number, nature of injury means we will write whether it is abrasion, contusion, laceration, then the size. Size has to be medical officers. Please take care. If it is a laceration, it has to be a 3 dimension. Most of these people are writing that it is only 2 dimensions they are writing for laceration. So that is not correct. So please take care. Contused and lacerated wound, stab wound, perforated wound, fractures, open fractures always should have a 3 dimensions. 3 dimensions means length, breadth, and depth. Then location on the body means we have to fix it anatomically where it is located. Just writing a CLW on right hand is not right. I have to write CLW of size say 1 into 2 into 3 centimeter over right hand, dorsal aspect or ventral aspect, say 2 centimeter below the right wrist. This way ideally has to be written by a doctor so that anatomical fixation of injury can be fairly done by the honorable court and proportionate punishment can be awarded to the accused. See, this is again a type of injury, means this column basically relates that the medical officer is expected to write whether say serial number 1 injury abrasion they have written, whether it is simple or grievous. This column has to be that. Then kind of weapon. So medical officer has to say injury number one, abrasion. Which type of kind of weapon it can be inflicted? Say sharp weapon or hard and blunt object or any other type of weapon, depending on the nature of injury. Then age of injury. If we can derive the age of injury, if it is an abrasion, we can easily derive. If it is a contusion, we can easily derive. In fractures, we can fairly derive. May not be precise, but fairly derive the age of the injury. So this is to be written. Now remarks, sometimes what happen? I may get a swelling over a right wrist and I may suspect underneath this swelling there can be fracture of radius or radius ulna. So what I will do, I'll write here contusion, size, location, type, kind, and I will not opine this column, simple or grievous. See this column. So medical officer should not opine on this, and I will advise X-ray in remarks that only after examination of X-ray I would be in a position to say whether it is a simple or grievous hurt. So these are all basic columns. Then downside has to be a opinion. Again, this opinion is not given by many medical officer. I don't know why they don't provide, and this poor investigating officer has to come day in and day out to hospital to derive this opinion. So it has to be a part of your certificate only. So opinion in this I have to clearly mention, say 5 injuries I have mentioned. So I and take example of out of that 5 injuries, 3 injuries I label it as grievous and 2 injuries are simple as per my opinion. So I have to start here from examination of the injuries, and if you have done x-rays, any investigation done I am of the opinion that injury number 1 and 3 are simple in nature. Injury number 2, 4 and 5 are grievous in nature. So this will give a clearer picture to the investigating officer. Then he can discuss with the law officers or any competent authority of investigating agency, and they will properly file section based on this injury report. Then there is signature and all basic detail. Doctor has to write as per new guidelines by Medical Council of India. Now NMC, any doctor, whenever I or any doctor is signing any medico-legal document or any normal document also, so below that sign, he has to put his name in clear words. He should put his registration number. So these three things are mandatory. But in courts, the way the signatures are done by doctor, and they are putting stamp, general stamp. If suppose one certificate is given by Sion Hospital, they will only put stamp CMO Sion Hospital. So from that signature, how anyone could derive that this signed doctor is XYZ. So I request all the medical officer, it is now mandatory as per NMC guidelines. In Ethics and Etiquettes Act, which was 2001 pre-4, has been amended by NMC, and now it is mandatory that a doctor, whenever signing any document, has to write his name in details. His registration number has to be there mandatory. And I would add upon this, along with this, doctor should give mobile number also nowadays. Sometimes what happens, these cases do come late on board, say 5, 6 years after, and that time the doctor might have not been in that institute. He might have shifted to any other hospital as per his wish. So then, if that mobile number is made mandatory under this, the investigating officer will be at ease to call that doctor and inform him, doctor, this is your date, these summons are being issued, because I have seen poor constable to issue someone to any doctor in government hospital, he has to spend complete day to search him. So this should not be there. We have Information Technology Act. We should make use of that for convenience of, because they are also equally overloaded. They can send us email, they can WhatsApp us summons, and we have to behave that someone court order. So this is what pro forma ideal has to be there. So this is conclusion. So in conclusion, what we can say about the injury report? An injury report plays a crucial role in bridging the gap between medical and legal consideration, ensuring that individuals receive appropriate medical care. So primary aim as per law, there are various citations in law that saving life of the patient is the prime objective of a doctor, and simultaneously all this procedure can be done. So it is ensuring that individuals received appropriate medical care, and if necessary, facilitating legal processes related to completeness, and related to compensation and liability. It is essential for accuracy, completeness, and timelessness in order to serve its medical legal purpose effectively. So, if we all medical officers, if we follow standard guidelines, give precise opinion, then providing justice by due process of law will be more easier, and all these victims would be at ease to get free and fair justice. At the end, I would say I've read one line morning only. We all know it is only a corroborative evidence. It is a established law. We are expert under 45 section of Indian Evidence Act, and whatever medical opinion or medical legal opinion given by any registered medical practitioner is only corroborative in nature as per law. But nowadays, if medical opinion is in good corroboration with the prosecution case, then conviction has been given by honorable court even after corroboration. And one of the medical evidence which nowadays is a clinching evidence is DNA profile report. Except twins or unipolar twins, this high profile DNA fingerprinting is enough to detect the maternity, paternity, or the accused in cases of maternity, paternity disputes. So medical evidence in last few years has gained importance solely because medical evidence is based on science, and science is well researched for years together. So thank you very, very much. Anything for me? Any cross questions? Questions?
Number
Yeah.
one, what is an accident report and a weapon report?
See, as such, accident report has no special entity. Accident report is no separate identity. Injury report is a identity which is established by medical science as well as the legal authority. Accident report nowadays, what happens, see, the problem in this is most of the private hospital do not know what is the proper medical legal science or law of this country. So every hospital derives their own conclusion. They may label injury report as accident report Q because this case is an accident and the injuries are because of accident. So we are providing accident report. So as such, there is no accident report which is established by due course of law or by any authority, competent authority. Now your corporate hospital may write anything. It is up to them. We cannot challenge them. So there is no such established entity of accident report.
Okay, so the next question is, what are the probable and questionable aspects in an injury report?
Probable and questionable.
Yes. Is there something like
Yeah,
that?
that I have discussed. Now I will give you a basic example. See, prosecution would be always saying that these injuries, what you have said, and the weapon which was recovered and which is shown to us in examination in chief, will always ask if these injuries are caused by this weapon. Possibility, they take possibility from us that whatever certificate is given, this is the weapon which has been recovered, and whether this type of weapon can cause such type of injuries mentioned by you in the wound certificate. So that is prosecution mainly is interested in that. And what defense is more interested is that to question us that if I label it as a grievous injury, because once I label it as a grievous injury, it mandates or it is a strong support to apply sections of IPC 326, and 376 is nowadays available by section court only, not by the magistrate court. So they will cross us that this is not a grievous injury. If I have read, if medical officer has opined about a say hairline fracture, there can be contradiction based on that whether this fracture is simple, if it is grievous, why patient has not died. So it depends on the case to case basically. But see, defense lawyer is more interested to take contradiction from us, to take benefit of doubt from us, saying that no, this all grievous injuries are simple in nature.
Okay, sir.
हॅलो सर ज्यावेळेस डॉक्टर मेडिकल परफॉर्म करत असते मेडिकल सर्टिफिकेट परफॉर्म करत असतात त्यावेळेस त्यांच्याकडून काय काय मिस्टेक होते
मेडिकल सर्टिफिकेट
जेव्हा ते इश्यू करत असते त्यावेळेस त्यांच्याकडून काय
इश्यू
मिस्टेक
करताना
हा
इश्यूचं रेकॉर्ड सेक्शन करतं
ते
ते लिहिताना म्हणताय का तुम्ही इंजुरी
परफॉर्म
लिहिताना
करताना
म्हणजे इंजुरी रिपोर्ट बनवताना
यस
बरोबर.
यस यस यस
आता हे जे परफॉर्म काही जागी चुकीचे आहेत, काही जागी इंजुरीज त्यांना लिहिता येत नाही नीट, हे चुका होतातच. कारण व्हॉट इज हॅपनिंग की MBBS झालेला डॉक्टर जो CMO असतो तो एवढा एक्सपर्ट नाही फोरेन्सिक एवढा. आणि फोरेन्सिक एक्सपर्ट्स आर नॉट अवेलेबल इन ऑल हॉस्पिटल्स. प्रॉब्लेम हा आहे का? ते काय करतात की जे जुने प्रोसिजर आहेत 2-3
Yes.
कॉलम त्याप्रमाणे लिहितात. आणि बऱ्याच वेळेस होतंय ना की एखादी CLW ते इनसाइज वुंड लिहितात, एखादी इनसाइज वुंड असेल, कारण दे आर नॉट एक्सपर्ट लाईक आम्ही जसं MD करतो त्या विषयात आणि एवढं आम्ही केस एक्झामिन करतो. वी आर experts in this. They are, as per Indian Evidence Act, they are also expert witness. But skills, if you compare, are better with the people who are doing MD forensic. तर ते नवीन पोरं MBBS झाल्यावर त्यांना ते एवढा अनुभव नसतो, तर दे मे मिस इंटरप्रेट. आता बऱ्याच वेळेस स्टॅब वुंडला इनसाइज वुंड लिहितात. आता जसं वेन आय सेड की कट लॅसरेशन, ते कट लॅसरेशन इनसाइज वुंड सारखे दिसतात.
हो सर.
मग इनएक्सपिरियन्स डॉक्टर जो फॉर एक्सपर्ट म्हणजे स्किल कमी, त्याला दिसणार अरे दिस इज इनसाइड वुंड, सो ही मे रॉंगली से इट इज इनसाइड वुंड. असं होतं बऱ्याच वेळेस.
Yes. Thank you, sir.
Hello, am I audible?
या प्लीज प्लीज.
I have a question which is slightly offbeat. आतापर्यंत आपण इंजुरी आणि क्रिमिनॅलिटी ऑफ इंजुरी बद्दल बोलत होतो.
राईट.
Slightly different take.
ओके
Now, here is a situation where a person goes to a doctor
ओके
for a particular treatment and he is advised surgery.
ओके.
During surgery and performing the surgery, the doctor accidentally cuts or there is an aberrations on the a part which is not to be operated. Now, as per medical counsel, it is it is not negligence, but it is just an accident.
No. Means there is an accidental cut, right?
Yes, during surgery.
Okay. Done.
Now you have answered part of it by asking the question accidental cut. That's
Okay.
precisely the point. So
Okay.
I basically cannot go to the police station saying that there is a cut, it is a grievous cut,
Okay.
and there has been no proper post surgical
Damages.
observations and treatment or cure given to the patient.
Right.
Now this admittedly cannot be a criminal negligence.
Okay.
Now
So,
can we
means what is your question? means
how will
basically?
medical counsel
See, now
decide
there are
whether-
two aspects in this. I will tell
Yes.
you. See, for negligence, criminal negligence, we are talking about under Section 304A, and after verdict given in Jacob Matthews case, there are many after verdicts. See, criminal negligence 4Ds has to be sufficed. That the damage is a direct consequences. See, damages has to be there on the patient
Yes.
to get criminality. Second, we need a mens rea. Once we from our side we say कि accidental cut हुआ है. So where is
Yes.
the mens rea?
Correct.
Right? If there is
Correct.
no guilty mind, how criminality is involved? You can best to best go for civil compensation or under law of tort and all this. We can do that. But
No, my
criminality.
question is, sorry. My
No.
question is, how will the medical counsel take action against the doctor?
In this, what if you complain to say Maharashtra Medical Council?
Yes.
They will form a committee of expert, their procedure. Right? Now, which part of body has been accidentally cut? And that because of that accidental cut, what are the damages suffered to the patient? Now that damages may be bodily or loss of, economy too. I will give an example. Nowadays, many a time, there are reports also. There is a shared in this now rich class of implantation of hairs. There are various methods, and there are deaths also, few deaths because of few techniques, and that was debated and still being debated.
Yes.
Now, if my profession, say I am a good model, female model, and my earning depends on my look.
Correct.
I go to one of the best dermatologists.
Right.
You may take, I will not name any good dermatologist. Okay. And there is some pigmentation over right side of face. And nowadays we have laser, many more methods to decrease the pigmentation. Now by that procedure they do, and accidentally, if after doing that procedure, that darkness increases pigmentation, right? Then because of that, she may lose some schedule, some modeling contracts.
Correct.
So in this case, see, unless and until there are damages, criminality cannot be involved.
Okay.
In this case, if there is a loss, Workmen Compensation Act is there. we can complain. So what medical council can do in this, they
Hmm.
can question this doctor
Hmm.
in this way. Now, whatever defense he takes,
Hmm.
this council concern is, see where council is involved,
Hmm.
what action they are allowed to take as per act. First is to issue warning notice.
Hmm.
If the mistake or the allegation is not of grievous nature,
Hmm.
they will warn that doctor ki this has been, we have inquired, and
Okay.
first warning is issued to us, and henceforth if such any activities are alleged against you, we'll
Hmm.
take it on seriously. This is the first.
Okay.
Secondly, if there is criminality involved,
Hmm.
they can deregister partly for specific period of time. You go to
Okay.
NMC site, regular actions are taken.
Okay.
Last month only, we have taken action and we have deregistered temporarily
Okay.
ex-doctor from one state for 3
Okay.
months.
Okay.
So for that 3 months, he doesn't exist to be a doctor.
Okay.
That doesn't mean his license has been revoked.
Okay.
And it's just like giving an entry relief by any court.
Okay.
And just like courts give protection orders. That doesn't mean ki your FIR is quashed.
Okay.
Right? So
Okay.
that is the second step. Third is, if there is criminality involved and that act amounts to a case of res ipsa locator, that is the fact speaks for itself,
Right.
then he will lose his license.
Okay.
So this is the way, means first you have to go to Maharashtra Medical Council, and if you are not satisfied with Maharashtra Medical Council, you can very well go to Indian Medical Council, or now it is National Medical Council.
Okay.
But along
Fine.
with this, simultaneously, you can complain in civil courts, consumer redressal
Consumer.
forum.
Yeah. Correct.
Yeah, it can go simultaneously.
Thank you. Thanks
Thank
a
you,
lot.
sir. Thank you.
Thank you for the insight.
Good afternoon, doctor. My question is a little in line, but a little further. Can you please show a PM report if possible, and specifically in the report?
Written PM report.
Yes, and
Go
if you
empty.
can just give the keywords which will help us to understand, like how a doctor is going to give the keywords to differentiate between a murder and culpable homicide.
No, you want a ideal PM report to be seen.
Yes, sir. If possible, I would really love
I
to
will
see
share
that.
a PDF na, with these people, they will share it. Because this basic thing, that is the reason I requested Malvika of PLEA that we'll go by basics first, rather than directly dealing with negligence and all this. So that
Sure.
I will share, sir.
Thank you.
I just wanted some idea on non-cognizable injuries.
Non-cognizable injuries are all simple injuries in short. NC
Yeah, but
injuries, we have already defined. See, I told clearly there is no legal definition for simple injury. But in one of the Supreme Court order, this 319 definition of hurt is said to be a synonym of injury, simple injury. So all such simple injuries would be non-cognizable injuries.
okay, considering that there is a criminality involved in that, that's
See, if there is, even though it is a simple injury, it has to be criminality involved, na? Because there was a mens rea to injure a person.
yes. Okay,
If it may vary, it may be serious or simple.
okay. Sir, thank you. Excellent performance.
Thank you. Thank you. Thank you.
हा सर द क्वेश्चन इज थोडस डिफरन्स मला सांगा ना एडीआर
बोला.
आणि पोस्टमार्टम रिपोर्ट आणि इंजुरी सर्टिफिकेट या तीन
काय
मध्ये
काय ADR?
एडीआर ऍक्सिडेंट डेथ
ADR चा ऍक्सिडेंटल डेथ रिपोर्ट आहे. तो PM ला जेव्हा बॉडी येते,
हा.
बॉडी इज ब्रॉट फॉर PM,
जी
पत्रक 1 आणि 2 देतात. दॅट इज ADR कॉपी. दॅट इज ऍक्सिडेंटल डेथ रिपोर्ट.
ओके बट इंजुरी रिपोर्ट कॅन बी फर्दर इफ द विक्टिम डाईज इन द मीन टाइम
Yeah, why not? I told na.
So
A
it is
patient may be admitted. See
Ha.
what happens if there are serious injuries, he is admitted in hospital. He survives. So even though he survives, injury report is taken from medical officer by police. May after 10-15 days, he may succumb to death.
Yes.
10-15 दिवसांनी तो मरू शकतो कशाने.
जी
So in that मग त्याचं ADR होणारच ना. This injury report will lay with the police. मग त्याची PM झाल्यावर PM रिपोर्ट मध्ये त्याच्या सर्व इंजुरी येणारच ना.
हा म्हणजे पीएम रिपोर्टला इंजुरी रिपोर्ट शॅल बी टॅग्ड इनिशियल इंजुरी
No. Injury report is given by casualty medical officer. See, where injury report is prepared at the entry of the hospital. म्हणजे प्रत्येक हॉस्पिटलला एक जेव्हा इंजुर्ड केस येते, इट विल कम इन कॅज्युअलिटी. तिथे MLC नोंद होते, सगळ्या गोष्टी होतात. ऑन ड्युटी जो कॅज्युअलिटी मेडिकल ऑफिसर आहे, he will first examine that case.
and the PM report is prepared by
The doctor who conducts PM. Simple.
that is the autopsy.
Autopsy, yeah.
And sir, one more question है. In a 307 case under IPC, there are wounds of machete attack on the skull. म्हणजे डोक्यावर कोयत्यानी वार आहेत. And 4 accused are there. All 4 are under JC for 3 months. So if the injury certificate is lenient on one of the accused, can he be discharged from the FIR? Can
I
it
already
be proved in the
explained
court?
this in under
Ah.
section 300 third
Ah.
part. See, बऱ्याच वेळेस करतात आता. See, means you're all top criminal counsels discuss with me in this, Mumbai or abroad also. Basically, when there are more than one accused and more than one injury and more than one weapon,
जी.
this defense is taken by one of the advocates say ki I am for say accused number 3, and as per prosecution say he was holding a bamboo stick and the injuries which has led to death was a incised or a stab wound. So my person has not hit, and whatever injury sustained by my client has not resulted in death. So minimization of punishment can be. So already they apply 34 section in such case, furtherance of common intention.
Yes.
What we can do, we can minimize 302 proper 300 मध्ये घेऊ शकतो. बरेच चांगले जे तुमचे
Depending on the arguments put
yes, जे चांगले लॉयर क्रॉस करतात.
Yes, yes.
बरेच आहेत आता. सुदीप पासबोला आहेत, सिनियर पॉन्ड आहे, बरेच चांगले लोक, बरेच केस त्यांनी केलेले.
Time is very less and there is a lot to learn from you.
He is always a learning process.
Before I leave, injury certificate is what is the importance of injury certificate under the DV Act? एक short मध्ये याच्यावर हे करून
Domestic Violence Act.
जी.
See, there are 2 types of injuries in DV. First are physical injuries, which is easily seen by the eyes of the medical officer. He can give injury report on that. Second is psychological injury. For psychological injury, we need help of counselors and psychiatrists. So that is always a combined opinion. So DV Act is not only physical injury. More DV Act we examine here, we have injured. We do it for last 10 years. So if there are no physical injuries, we have to go for psychological.
Fine, sir. Thank you so much.
Thank you. Thank you.
This question is pertaining to motor accident case in an injury or a fatal case. Now, in an injury case, can a doctor who is not the treating doctor, where he examines the patient clinically and identifies disabilities, whether
after being treated, after being treated.
Yes. After being treated, before filing the case or after filing the case, whether partial or permanent, whether such doctor is authorized to issue the disability certificate.
For disability certificate, government has approved some boards and some hospitals. Okay.
Yes.
So they can only, that medical board can only opine. See, now private opinion you can take from anyone. See, now law doesn't forbid me to take a private opinion, but that opinion, whether how much would be approved by the honorable court is a question mark. But if the opinion is taken from a board which is constituted by government instructions or government GR or government hospital like JJ, KEM, Sion, Nair, we have separate Haji Ali Government of India Disability Board.
Yes.
So they have right to give, and that opinions are widely agreed upon by the court.
Yes, no, here the question is that's why they are not from the government authorized doctors, but they are from the private doctor who is not a treating doctor.
So you can question them. They have no authority to give such opinion.
No, they say they have authority. So what is that authority which
now
comes
I will give you say. Now on what base they will argue is, we are also expert as per section 45 of Indian Evidence, which cannot be denied.
Yes.
Okay.
Yes.
Which cannot be denied.
Yes, sir.
Right. A orthopedician working in government hospital and a orthopedician in corporate has equal degrees.
Yes, sir.
Skill may differ depending on his practice.
Yes,
Skill is not degree dependent. We also know.
Yes.
Same applies to law. We have senior counsels, same degree, but better skill.
Yes. Yes, sir.
So you may say, you may have skill, but you are not authorized to give such opinion. Are you authorized to give opinion by government agencies? See, there are 2 questions in this. Then I am also MD forensic. Private medical college teachers, they are also forensic department. They can also do PM and write PM report, and they will say कि हमारी एक ही degree है, तो मेरा PM report मान लो आप.
So where does this authority come from? They need to have some certificate.
Government circulars, yeah.
So they can
They should
produce
have
that. They
approval
must
of
have that. They must
competent
have that
authority.
certification.
No,
No,
see,
the private doctors who give
Uh,
certificate, they must have some
for what?
certificate.
Disability we are talking, right?
Yes, sir.
You're not generalizing.
No, only disability, injury
Yeah, yeah.
claim, motor accident. So do they need certain certification who is not a treating doctor and a private doctor?
See, as per government procedure, to give a disability certificate, government has authorized few medical colleges. That
Yes.
medical colleges or civil hospitals have their own medical board.
Yes, sir.
They have orthopedicians, psychiatrists. There are 5 to 7 people in that.
Yes, sir.
So they are authorized, competent authorities. See,
Yes, sir. But what happens, sir? This treating patients, claimants in motor accident don't get it because they will give the right disability. To get more compensation, they take the certificate from a private doctor. Now, how to identify whether that doctor he says, when you put him in cross, he says, I have the authority. But
show
what
it
is,
now.
you
Show
need
it now.
certain certificate? I am asking you, do you need certain certificate to issue disability certificate, or it's a random, how to
See
that.
now, you can asking if you are authorized by any government agency or competent authority, shows that letter. Simple.
Okay.
Just like there is a circular from Government of Maharashtra Health Department. How many medical colleges are authorized to form a medical board?
Yes, sir. Yes, sir.
Simple.
Yes,
Let
Yes,
him
sir.
show him na.
Yes, yes. Thank you for that.
And the
One more
court has to
question.
reject then. See what happens, in your tribunals. I know. means
No, sir. This
you-
is
you-
a
the
what court
court
says. It's a summary and welfare legislation. So they are not very strict on this. Under the
They should be
disguise of
strict. Na?
welfare.
If
Yes,
one of your MBA judge denounces that judge opinion, he may say you are not authorized by government. There are government medical
Yes.
boards formed for this purpose. You
Yes.
take it from them and we'll decide
Yes.
based on that.
Yes.
That can be done. Na?
Yes, courts are looking into it, but the normal routine procedure is daily. We are facing this in tribunals. They are,
One good order from Honorable Court
yes, yes, sir.
denying such private certificates of orthopedicians
Yes, sir.
will clearly innovate all other people to do so.
Yes, sir. Yes,
And
absolutely.
you
sir.
have in Mumbai, there are 4 medical colleges having medical boards.
Yes, sir.
JJ is there, KEM, Nair, and Sain.
Yes.
So you approach anyone, they will
Yes.
form
They
a
don't
medical
do that,
board.
sir. They know that. The
They
claimants
will
also
examine
know.
everything.
Yes,
See,
sir.
giving a disability को 1 घंटे का काम नहीं, it takes days to get.
Yes, sir.
ऐसा है ना कि there are 7-8 departments involved in counseling and examination.
Yes, sir.
चलो.
One more question follows is how to identify which injuries are recoverable in injury cases of accident. Because even after a few years, they have a driving license or whatever. When we look at them in witness, they look okay, but they say, I cannot do this, I cannot do that, I cannot raise my hand. That is very easy to.
So then they should get examined from government hospital. That is the reason. Ask them to get examined from government hospital and provide an opinion that suppose there was a right ulnar fracture. Fracture is treated and how much percentage mobility has been lost. Simple. They should
Yes,
proof.
yes.
ना वो खुद doctor
Yes,
नहीं
sir.
है ना.
Yes, sir. Yes, sir.
See, in Motor Vehicle Act and Tribunal, most of the things are shown to get for compensation.
Yes,
You
sir.
also know, I
Absolutely.
also know.
Yes, sir.
So the court, the prosecution side has to object and the honorable court has to give proper directives कि जा तुम उधर हो government hospital से give us a opinion. If they say तुम्हारा 50% mobility नहीं है, we'll provide you as per that. See, one good order for this na.
Yes. Yes, sir.
We all know what happens.
We are
in-
all waiting, sir, for such one good
No,
order.
prosecution counsel, PP has to take a lead. See,
No,
defense
sir,
will not take a lead.
there's no
Because
PP
they
here
want
in this
client-
case. They are insurance company, private clients or insurance company. It's like that. So they
Whatever
take
it may be,
compensation
you
from
know.
insurance company. Yes, sir.
The victim side counsel, he may be from insurance or he may be from anyone, will always demand higher compensation.
Yes, sir. Yes, sir.
Right.
Yes, sir.
So we should not expect from them.
Yes, sir.
One
Yes,
good order or PIL in High Court, and if there are directives for this compensation, there are various medical boards formed by Government of Maharashtra, and these medical colleges are tertiary unit,
Yes, sir.
much higher unit than corporate hospital. You
Yes,
take
sir.
opinion from competent board, and based on that, we'll provide further or whatever. This is
Okay.
done. Na.
So independent reference can be made, and that particular government hospital can act on it and issue such
Why
certificate.
not? Why not?
Okay.
We are giving routinely in all medical colleges, not for this year.
Okay, sir.
You go to
Okay.
JJ.
Thank you very much.
All
Yes.
civil hospital have a disability board under civil surgeon. Is already in place. There is nothing new in this. Okay. Thank you.
Okay. So thank you so much, sir, for providing your valuable insights and your immeasurable contribution to our platform. Thank you so much, sir. Really can't thank you enough.
Thank you. Thank you very much.